This is Sudhir Kumar, the Vidya Assistant Professor, Gemtech School of Law. Today I am going to discuss the topic in the introduction of the Indian evidence and the nature of the Indian evidence under the subject law of evidence. As we know, the ends of justice, the end of law are met by establishing the rights, duties, and liabilities of a particular person or persons before the court. The very basic law which defines the rights and liabilities of a person is called the substantive law. For example, in India, it is the Indian evidence, it is the Indian Penal Code. And however, in order to establish the applicability of a specific substantive law, it is necessary to follow certain procedure in the code, and that procedure has been given. For the criminal law, it is the criminal procedure code, and in civil law, it is the civil procedure code. And also there are certain rules of law which deal with the mode of proof, the existence or non-existence of these rights, duties, and liabilities, and for that particular purpose there is the law of evidence, and in India it is the Indian Evidence Act 1872. Now the very basic question arises: what is the nature of the Indian Evidence Act? If we analyze the provisions of the Indian Evidence Act, we find that Indian Evidence Act is partially procedural and partially substantive. Reason being, it contains the provision related with the procedural law and the substantive law. For example, the rules related with the estoppel is totally in the nature of the substantive law, and the rules related with the examination of the witness, whether it is examination, cross examination, what question may be asked, what will be the acceptancy, all is the nature in the nature of procedural aspect. So it is also contains the procedural law as well, procedural aspect as well. That's why the Indian Evidence Act known as the adjective. Now question arises: what is the need of the evidence? The need of the evidence is to establish the particular fact, so that the right and liability may be established. And when there is a question of right and liability, then there must be some question which must be decided to establish the right and liability. Generally it is known as the fact in issue, and this fact in issue may be established by the various facts, and these various facts are called as a relevant fact under the Indian Evidence Act. There might be a multitude of facts which surround a given fact in issue, but every fact will not be relevant. So the court first has to examine as to what facts will be relevant, and then the court has to be satisfied the truthfulness of the relevant fact. These facts may be established by the oral or documentary evidence. When it is oral, it is generally the statement of the witnesses. Who will be the witnesses? What type of the documents are admissible? All is dealt in the Indian Evidence Act. There are certain facts which court take in the notice without proving. For example, the map which has been released, map of the India, map of the country which has been released by the government of India. And after considering all the evidence which has been laid before the court will appreciate the evidence, and then the court will deliver the judgment. Thank you.